Hi friends, this is a new channel. I have created a channel to impart legal knowledges, and my name is Daisy Roy. I have completed my LLM on criminal law. So this channel I have created to impart my knowledge that I have acquired through years of my formal education to you people, to have to know about the important part of the provisions of laws, so that it will help you to for your exam purposes to better understand the topics, because I'll be discussing all the points in points and also in a simple language, so that everyone would be able to understand it properly. So today I'll not only be discussing on the criminal law subjects, but also the civil laws. So today in this first video I'll be starting the civil procedure code 908. So this will be the introduction part of the civil procedure code. So if you like, please do like and share my video, and also subscribe to my channel. So I'm starting now. So to talk about the introduction of the Civil Procedure Code 1908, it came into force on 1st January 1909, and so on the first from 1st January 1909, it started to came into force in India. So now the extent and applicability of this code. This code applicable to whole of India, except to the state of Jammu and Kashmir and to the state of Nagaland and the tribal areas. So, and also it extends to the Amindavi Islands and the East Godavari and the Vishakhapatnam agencies in the state of Andhra Pradesh and the Union Territory of Lakshadweep. So, it also extends to the Amindavi Islands and the East Godavari and the Vishakhapatnam agencies of the state of Andhra Pradesh. And also by the Amendment Act of 1976, it extended to the scheduled areas also. So the most the when the code came into force, that is the date, the 1st January 1909. It's important for exam purposes and also for the competitive exams, and also the extents and applicability. It extends to uh, which of the states it is important. So, and now the code uh, is comprised of two parts. Okay, it comprises of the sections and the orders, we know this. So, and basically law, if we talk about laws are classified into two parts, that is the substantive parts and the procedural parts. So the substantive parts, we know that it defines the various principles regarding the rights and liabilities of, like for example, the Indian Penal Code 1860. It describes the various offenses punishables, and another part is the procedural part. It is concerned with the enforcement of the rights and liabilities that is determined in accordance with the rules of substantive laws. So what is a substantive part? It is it defines the various principles of the rights and liabilities of the people, and the procedural part is concerned with the enforcement of those rights and liability that is provided under the substantive laws. So procedural law, the most important example is the civil procedure code itself, because the civil procedure code, it regulates the procedures that has to be followed by the civil courts in India. And to talk about the criminal part, the criminal procedure code will deal with the criminal parts. So now the civil procedure code 1908 will deal with the procedural part, okay, of the cases of the civil code. So now the most important thing is that the civil procedure code, as we know, there it comprises of the section and the orders. So we will say it is comprised of two parts. The first part is the scheme of the code, the body of the code, which is comprised of the parts and the sections. Under the civil procedure code, there are 12 parts and 158 section. And another part is the schedules. The schedules are the procedures, the methods of manners in which a jurisdiction of the court may be exercised. So the schedules are the procedural part of the code, and the parts and the sections are the substantive part of the civil procedure code. The substantive part, that is the body of the code, which is comprised of the parts and the sections, it lays down the principles that has to be followed by the court. It lays down the power of the court. The power of the court to deal with the cases, the jurisdiction of the court. Basically, the sections deal with those parts, the jurisdiction, the power of the civil court. And the second part, that is the procedural part, that is the schedules. While enactment, there were 5 schedules, but later on it was repealed, and now there is only one single schedule, the first schedule, which consists the orders, and there are 51 orders, and each orders contains of various rules, and it will vary from orders to orders. So various orders have various rules. Now the schedules and the sections. The schedule comprise of the orders and the sections and the parts. It's a body of the code. So the body of the code, it can be amended only by the parliament. It cannot be touched by any court in India. So it can be altered, amended only by the parliament, and but the orders, it can be annulled by the high courts, and the high courts of various states, it can add or alter the orders as per their, in accordance with the circumstances of their cases of any states, and the high court can exercise this power under section 122 to 127 of the code itself, and also under section 129, 130 and 137. So basically the power of the high court to alter, add the orders, it's under section 122 to 127, 129, 130 and 131. So these sections are important. We should know about this section because it tells us about the power of the high court. It is provided under which section, so just mark it. So but one thing is that the high court cannot it should the rules that they are made, it should not be inconsistent with the sections. So they have to be they have to make in such a manner it is not inconsistent with the provisions of the sections. So, and whenever there is inconsistency, if it is sometimes if there is inconsistency between the orders and the sections, or the rules or the sections, then only the sections will be prevail. So the things that has to be kept in mind, that is important from the introduction part, is the date of its commencement, that is 1st January 1909. Then secondly, its applicability and extent. It extends to which part of the India, and which and it doesn't extend to which part. So these 2 things are important. Thirdly, whether the civil procedure code, the scheme of the code, that it is substantive as well as procedural part, and the substantive part are the sections and the procedural parts are those orders. So, and the orders, it cannot be amended, it can be amended or altered only by the high, it can the sections and the sections can only be amended by the parliament. It cannot be touched by any high court, but the orders can be altered as per the convenience by the high courts. And whenever there is inconsistency between the sections and the orders or the rules, only the sections will be prevail. So I am concluding the introduction part in this video. The other main provisions of the code will be discussed by my later videos, will be discussed on the other videos. So do like and share and also subscribe to my channel, and thank you so much.